The morning the power went out for the third time in 6 months, I sat in my home office watching my computer screens flicker and die, taking 3 hours of unsaved CAD work with them. My name is Vincent Dalton, and I'm a mechanical engineer who works from home designing HVAC systems for commercial buildings across Texas. That power outage cost me a client deadline and about $15,000 in potential revenue. I wasn't going to let it happen again. The Riverside Estates HOA in Sugar Land, Texas, where I'd bought my house 2 years prior, had always been particular about appearances. Lawn height regulations, approved paint colors, the whole 9 yards. But they'd never bothered me much since I kept to myself and maintained my property well. My 3-bedroom ranch-style home sat on a corner lot, which gave me decent privacy and a sizable backyard. The neighborhood itself was pleasant enough, built in the early 2000s with mature trees and winding streets designed to slow traffic. Most of my neighbors were either young families or retirees, and everyone generally minded their own business. After that third outage, I drove straight to a commercial equipment supplier in Houston and dropped $25,000 on a Cummins diesel generator capable of powering my entire house. It was a beautiful piece of engineering, a 50 kW unit with automatic transfer switching and enough fuel capacity to run for 72 hours straight. I hired a licensed electrician to install it properly, pulled all the required permits from the city, and had it inspected. Everything was completely legal and up to code. The generator sat on a concrete pad in my backyard, about 15 feet from my property line, surrounded by professionally installed acoustic dampening panels that reduced the operational noise to about 65 decibels at 20 feet. For reference, that's quieter than normal conversation. The installation took a week, and I was proud of the setup. No more lost work, no more spoiled food, no more sitting in the dark wondering when the power company would get their act together. I tested the generator on a Saturday afternoon, letting it run for about 4 hours to make sure everything worked correctly. The electrician had done excellent work. The transfer switch activated smoothly, and inside my house, I barely noticed the difference. The unit hummed quietly in the backyard, barely audible over the ambient neighborhood noise. On Monday morning, I found the first notice taped to my front door. The letter was printed on cream-colored cardstock with the Riverside Estates HOA logo at the top. It informed me that I was in violation of Section 12, Paragraph 4 of the HOA covenants, which prohibited excessive noise generation and unsightly mechanical equipment visible from the street or neighboring properties. I was being fined $500 and ordered to remove the generator within 30 days. I read the letter 3 times, feeling my blood pressure rise with each pass. The generator wasn't visible from the street at all. It was behind my house, surrounded by the acoustic panels that matched my fence color. And excessive noise. I'd specifically invested in the dampening system to keep it quiet. This was ridiculous. That afternoon, I drove to the HOA office located in the community center near the neighborhood entrance. The receptionist, a tired-looking woman in her 50s, directed me to wait in the lobby. 15 minutes later, I was ushered into a small conference room where 3 HOA board members sat behind a folding table like they were presiding over the Supreme Court. The president of the board was a woman named Barbara Kensington, and she was exactly what you'd expect. Mid-50s, blonde highlights that were too blonde, wearing a cream-colored blazer that probably cost more than my generator installation. She had that permanent expression of disapproval that some people develop after years of finding fault with everything around them. "Mr. Dalton," Barbara said, not bothering with pleasantries. "Thank you for coming in. I assume you received our notice regarding your code violation." "I did," I said, keeping my voice calm, "and I'm here to contest it. My generator is fully permitted by the city, installed to code, and meets all noise ordinances. It's not visible from the street, and the sound dampening keeps it well below acceptable decibel levels." Barbara exchanged glances with the two other board members, a thin man named Gerald and a younger woman named Patricia. "The HOA covenants supersede city ordinances in matters of community standards," Barbara said. "Several neighbors have complained about the noise." "Which neighbors?" I asked. "And when?" "I've only run it once for a test." "We don't disclose complainant information," Patricia chimed in. "But the board has reviewed the situation and determined that the generator constitutes a violation." I pulled out my phone and showed them photos of the installation, along with the decibel readings my electrician had taken. "This is a professional installation with acoustic dampening. The noise level at my property line is 65 decibels. City ordinance allows up to 75 during daytime hours. The HOA covenants don't specify a decibel limit, just excessive noise, which is subjective. My generator doesn't meet any reasonable definition of excessive." Barbara's expression hardened. "Mr. Dalton, the board has made its decision. You have 30 days to remove the generator or face additional fines of $100 per day." "This is insane," I said, my calm starting to crack. "I need this generator for my work. We've had 3 major power outages this year. I'm running a business from my home, and those outages cost me real money." "Perhaps you should consider alternative arrangements for your business," Gerald suggested with a thin smile. I left the meeting furious, but determined to fight this properly. Over the next week, I sent certified letters to the HOA board citing the specific sections of Texas property law that protected my rights as a homeowner. I included copies of my permits, my installation inspection results, and a letter from a noise abatement consultant confirming that my generator produced less noise than a standard air conditioning unit. The HOA responded by rejecting all my arguments and increasing my fine to $1,000, with the daily penalties starting in 3 weeks. That's when I met Marcus Rodriguez, the man who would become both my ally and the key to the HOA's eventual downfall. Marcus lived 4 houses down from me, a quiet guy in his early 40s who worked as an electrical engineer for one of the major energy companies in Houston. I'd seen him around the neighborhood, but never really talked to him beyond basic waves and hellos. He knocked on my door on a Wednesday evening, holding a 6-pack of beer and looking concerned. "Hey, Vincent," he said when I opened the door. "I heard about your generator situation with the HOA. Mind if I come in for a minute?" We sat in my living room, and Marcus explained that he'd been following my dispute with interest because he'd had his own run-ins with Barbara and her board. 2 years ago, he tried to install solar panels on his roof and faced similar resistance, eventually winning only after threatening legal action. "The thing is," Marcus said, "I'm actually the person who designed and installed the backup power system for our community center and pool house. The HOA hired me 3 years ago because of my expertise. That system includes a generator that's actually louder and less efficient than yours." I sat up straighter. "Are you serious?" "Completely. It's a 75 kW unit without any real acoustic dampening. It sits behind the community center, but you can hear it clearly when it runs." And Barbara pushed hard for that installation because she was worried about the pool losing power during summer storms and parents complaining. "So they have no problem with generators when it benefits them," I said. Marcus nodded. Barbara doesn't like you because you didn't come crawling to the board for permission before you installed it. She thinks every homeowner should ask the board before making any improvements, even when it's legal. It's about control, not actual rules. Over the next hour, Marcus and I talked through my options. He offered to write a professional assessment of my generator system and testify at the next HOA board meeting if needed. He also mentioned something that caught my attention. "I've actually been thinking about moving anyway," Marcus said. "My wife got a job offer in Austin, and we're considering taking it. But I hate the idea of leaving the HOA to bully other homeowners after I'm gone." A seed of an idea planted itself in my mind, but I didn't mention it yet. The next board meeting was scheduled for the following Thursday. I prepared thoroughly, printing copies of all my documentation, including Marcus's professional assessment. Marcus agreed to attend with me, lending his expertise and credibility to my case. The meeting was held in the community center's main room, with about 30 homeowners scattered across the folding chairs. Most people attended these meetings out of obligation or boredom, but word had spread about my generator dispute, and I noticed several neighbors watching with interest. Barbara called the meeting to order and worked through the standard agenda items first: landscaping updates, pool maintenance schedules, the upcoming summer festival. Finally, she reached my case. "We have a continued matter regarding Vincent Dalton's unauthorized generator installation," Barbara announced, her voice taking on a formal tone. "Mr. Dalton has requested time to address the board. You have 5 minutes, Mr. Dalton." I stood and walked to the front of the room, refusing to be intimidated. "Thank you. I'm here to demonstrate that my generator installation is fully legal, properly permitted, and in compliance with all applicable noise ordinances. I've provided detailed documentation to the board, including professional assessments from licensed engineers. I went through my evidence point by point, keeping my presentation clear and factual. I showed photos, played a recording of the generator's actual noise level, and cited the specific Texas property statutes that protected my installation. Furthermore, I continued, the HOA's own facilities include a backup generator that produces more noise and has less sophisticated dampening than mine. The community center generator, which I can prove through decibel measurements, regularly exceeds the noise level of my residential unit. Barbara's face flushed red. "That's completely different. The community center serves all residents. The law doesn't make distinctions based on who benefits from the equipment," I said. "Either generators are allowed or they're not. The HOA can't have one for itself while prohibiting homeowners from having them." Marcus stood up from the audience. "I'd like to add something if I may. I'm Marcus Rodriguez, the electrical engineer who designed the community center's backup power system. I've reviewed Vincent's installation, and it's superior to the system I built for the HOA in every measurable way. It's quieter, more efficient, and better integrated with the home's electrical system. If the board has concerns about generators, they should start by upgrading their own before fining residents for better installations." Several homeowners murmured in agreement. Barbara looked like she wanted to explode. "The board will take your comments under advisement," she said through gritted teeth. "We'll provide our decision in writing within 10 business days." I knew right then that I wasn't going to win, no matter how solid my case was. Barbara had made this personal, and she wasn't going to back down. Sure enough, a week later I received a certified letter upholding all fines and violations. The letter included new citations, claiming that my generator pad violated setback requirements. It didn't, and that the acoustic panels were non-conforming structures. They weren't, according to city code. The total fines now stood at $2,000, with daily penalties of $200 set to begin immediately. I could have fought this in court. I probably would have won eventually. But the legal fees would have been substantial. The process would have taken months, and I'd have to continue living in a neighborhood where the HOA president had made me her personal enemy. Every inspection would be harassment. Every minor issue would become a violation, and my life would be a constant battle. That evening, I sat in my home office and did something I never thought I'd do. I started looking at real estate listings in other cities. The thing about being a mechanical engineer who works remotely is that I can live anywhere with good internet. I'd chosen Sugar Land because it was close to Houston's industrial corridor and my clients, but I could just as easily work from Dallas, San Antonio, or even out of state. And the more I thought about it, the more attractive the idea became. Over the next few days, I expanded my search. I looked at Austin, where Marcus and his wife were planning to move. I looked at smaller cities in the Hill Country. I even considered leaving Texas entirely, though I wanted to stay relatively close to my elderly parents in Corpus Christi. Then I found it. A property in Dripping Springs, about 30 miles west of Austin. 4 acres, no HOA. A renovated farmhouse with a detached workshop, fiber internet, and room for whatever generator I wanted to install. The price was reasonable, and the location put me within an hour of Austin-Bergstrom Airport for client meetings. I scheduled a viewing for the following Saturday. The property was even better in person. The house was a 1970s ranch that had been completely updated with modern systems and finishes, but maintaining its original character. The workshop had 3-phase power, perfect for my needs. And the 4 acres meant my nearest neighbor was far enough away that they'd never hear my generator, even if I ran it without any dampening. I made an offer that afternoon, $20,000 below asking but still competitive. The sellers, a retired couple moving to be closer to their grandchildren in Florida, accepted by Monday morning. The reality of what I was doing hit me that evening. I was leaving a house I'd owned for just 2 years, taking a loss on closing costs and improvements, all because of an HOA dispute. Part of me felt like I was running away, letting Barbara and her petty tyranny win, but another part of me felt liberated. No more HOA meetings, no more violation notices over lawn height or mailbox color. I could build what I wanted, maintain my property how I wanted, and live without someone else's arbitrary rules dictating my choices. I called Marcus the next day. "Hey, I wanted to let you know I'm moving. I bought a place in Dripping Springs." There was a pause on the line. "Seriously?" "Because of the generator thing, partly," I admitted. "But also because I'm tired of dealing with HOA nonsense. Life's too short to fight with Barbara Kensington over whether my backup power is too loud. The new place has no HOA, plenty of space, and I can run my business without worrying about my power going out." "I don't blame you," Marcus said. "That's actually why I wanted to talk to you. My wife officially accepted the job in Austin. We're moving in about 6 weeks. I was going to call you because I need to resign from my position as the HOA's backup power consultant, and I wanted to coordinate with you on it." An idea crystallized in my mind. What if you resigned immediately and cited my case as the reason? Marcus laughed. "I've actually been thinking about that. Barbara's going to lose her mind. The community center generator is due for its annual maintenance next month, and I'm the only one who knows how to service it properly. The original installer went out of business." "Even better," I said. "Let her reap what she's sown." We talked for another 20 minutes, refining the plan. Marcus would submit his resignation to the board at their next meeting, which was scheduled for 2 weeks out. He'd be professional but clear about his reasons. And he declined to recommend a replacement or provide any transition assistance beyond basic documentation. I felt a savage satisfaction at the plan. It was petty, maybe, but it was also perfectly justified. The HOA had pushed me out over a legitimate business need, and now they'd lose the expert who maintained their own backup systems. The next 2 weeks flew by in a flurry of activity. I listed my Sugar Land house with a realtor, pricing it competitively to sell quickly. I started packing non-essential items. I notified my clients of my upcoming address change, and I paid off the HOA fines in full, just to deny them the satisfaction of continued penalties or collection actions. My house went under contract in 5 days. A young couple with a baby, moving to Sugar Land for work, fell in love with the place. They didn't care about the generator, which I disclosed upfront. In fact, the husband thought it was a selling point given the area's power reliability issues. The timing worked out perfectly. My closing on the Dripping Springs property was scheduled for a Friday, and the sale of my Sugar Land house would close the following Wednesday. I'd have a few days overlap to move my belongings without rushing. The HOA board meeting where Marcus planned to resign was on a Thursday, exactly 1 week before my move. I decided to attend, wanting to see Barbara's reaction in person. The meeting started normally enough. Barbara worked through the agenda with her usual self-important efficiency. Pool chemical testing results, landscaping bid approvals, someone's complaint about a neighbor's wind chimes. Then she reached the community center maintenance report. "I'd like to call on Marcus Rodriguez to provide an update on the backup power system maintenance schedule," Barbara said, glancing at her notes. Marcus stood up, holding a folder. He walked to the front of the room with the calm confidence of someone who'd already made up their mind and felt at peace with the decision. "Thank you, Barbara. Before I provide that update, I need to inform the board that I'm resigning as the HOA's backup power consultant, effective immediately." The room went silent. Barbara's head snapped up, her expression shifting from boredom to shock. "I'm sorry, what?" "I'm resigning," Marcus repeated calmly. "My family is relocating to Austin for my wife's career, and I can no longer provide services to the HOA. Additionally, I've become increasingly uncomfortable with the board's treatment of homeowners who install backup power systems. The recent dispute with Vincent Dalton, who installed a generator superior to the community center's system, demonstrated that the board applies standards inconsistently and punitively." Barbara's face flushed red. "This is highly inappropriate. You have a contract with the HOA." "My contract is as an independent consultant with a 30-day termination clause that either party can invoke," Marcus said, his voice steady. "I'm invoking that clause. However, I'm making myself available for emergency consultations during the next 30 days if the community center generator fails. After that, you'll need to find a new consultant." "This is because of Vincent Dalton, isn't it?" Barbara's voice rose. "You're friends with him, and this is some kind of coordinated attack on the board." "This is because of principle," Marcus replied. "Vincent is a homeowner who followed all applicable laws and regulations. He obtained proper permits, hired licensed contractors, and installed equipment that meets or exceeds all relevant standards. The board fined him anyway because you personally didn't like that he didn't ask permission first. That's not governance, Barbara. That's bullying." Several homeowners in the audience began murmuring among themselves. I noticed a few nodding in agreement. "The board has the authority to enforce community standards," Gerald interjected, trying to support Barbara. "The board has the authority to enforce the covenants as written," Marcus countered. not to make up new standards on the fly because you don't like a particular homeowner. Vincent's generator doesn't violate the covenants. You know it, I know it, and eventually a judge would know it too. But instead of admitting that, you've driven out a productive member of the community who was trying to protect his livelihood. Are you quite finished? Barbara asked icily. Almost. I've prepared a transition document that lists all the basic maintenance requirements for the community center generator. It's in this folder. Marcus placed the folder on the table in front of Barbara. Everything beyond basic operation will require a new consultant. Good luck finding one who will work with a board that treats technical experts as disposable the moment they disagree with your personal vendettas. Marcus turned and walked back to his seat. The room buzzed with conversation. Barbara tried to regain control of the meeting, but the damage was done. Several homeowners started asking pointed questions about the Dalton generator case, wanting to know the specifics of what rules I'd supposedly broken. I stood up. If I may address the board briefly. Barbara looked like she wanted to refuse, but too many people were watching. You have 2 minutes, Mr. Dalton. Thank you. I want the community to know that I'm moving out of Riverside Estates next week. I've sold my house and purchased property elsewhere. The HOA's treatment of my generator installation, which was legal and proper in every way, made it clear that I wasn't welcome here. I'm a mechanical engineer who works from home. I need reliable power. Rather than fight the board for months in court, which I likely would have won, I decided my time and money were better spent living somewhere that respects property rights and doesn't operate on the whims of whoever happens to be on the board. I paused, making eye contact with Barbara. I want to thank Marcus Rodriguez for his integrity and professionalism. And I want to warn my fellow homeowners to document everything, follow every rule precisely, and keep a lawyer on speed dial. Because apparently, doing things legally and properly isn't enough in this neighborhood. You also need Barbara's personal approval. The meeting devolved into chaos after that. Multiple homeowners started voicing their own complaints about the board's decisions. Someone brought up the solar panel dispute from 2 years ago. Another person questioned why the HOA generator was exempt from rules that applied to residents. Barbara tried to restore order, banging a gavel that I hadn't even noticed before. Eventually, she simply adjourned the meeting early, fleeing to the back office with Gerald and Patricia trailing behind her. Marcus and I left together, grinning despite the drama. Several homeowners stopped us in the parking lot, expressing support and asking questions about the generator case. A few even asked for Marcus's contact information for their own backup power projects. That felt good, Marcus admitted as we walked to our cars. I've been biting my tongue around Barbara for 3 years, worth it just for the look on her face. She's going to make your life miserable for the next 30 days, I warned. Only if I stay in the neighborhood, Marcus said with a smile. Our house closes in 3 weeks. We're moving in with my in-laws in Austin until then. Barbara can send all the strongly worded letters she wants to our forwarding address. We shook hands, agreeing to stay in touch. Marcus mentioned he'd be happy to consult on any HVAC projects I had that needed electrical engineering input, and I promised to send business his way. The next week was a blur of moving preparations. I rented a truck, packed my life into boxes, and said goodbye to the few neighbors I'd actually connected with. Most people were friendly, expressing regret that I was leaving and frustration with the HOA's handling of the situation. The closing on my new property went smoothly. The sellers were pleasant, handing over keys and well wishes. I spent that first night in the Dripping Springs house, sitting on the back porch, looking out over 4 acres of my own land, and feeling a weight lift off my shoulders that I hadn't fully realized I'd been carrying. The Sugar Land house closing happened on schedule. The young couple who bought it were excited and grateful, blissfully unaware of the HOA drama that had preceded their purchase. I wished them well and didn't mention the generator disputes. They'd figure out the HOA's nature soon enough, or maybe they'd have better luck with Barbara than I did. I thought that would be the end of the story. I'd moved on, escaped the HOA tyranny, and could focus on rebuilding my life in a place where I had actual freedom over my property. Marcus had relocated to Austin, started a consulting business, and was thriving, but Barbara Kensington wasn't done yet. 3 weeks after I moved out, I received a certified letter at my new address. The HOA was suing me for $5,000 in unpaid fines and property damages. According to their complaint, I had never properly removed the generator despite their orders, and the installation had caused structural damage to the property that impacted its value. I read the lawsuit in disbelief. The generator was still installed because the buyers had specifically wanted it. There was no structural damage because the installation was done professionally on a separate concrete pad, and I'd paid off all the fines before moving. I immediately called my real estate attorney, a sharp woman named Jennifer Castillo who'd handled my property closings. She read through the lawsuit and started laughing. "This is ridiculous," Jennifer said. "You paid the fines, the generator was disclosed to the buyers and included in the sale, and there's no damage. The HOA has no standing to sue you for property conditions after the sale, especially when the current owners have no complaints. This is harassment, pure and simple." "Can they actually pursue this?" I asked. "They can file whatever they want," Jennifer said. "Whether a judge will entertain it is another matter. I'll file a motion to dismiss on multiple grounds. This should get thrown out quickly, but you might want to countersue for harassment and legal fees." We scheduled a meeting for the following week to discuss strategy. In the meantime, I did some research on Riverside Estates HOA and discovered some interesting information. Texas has strict laws about HOA governance, including requirements for financial transparency, proper notice of meetings, and fair enforcement of rules. I started requesting public records from the HOA, which they were legally required to provide to former homeowners for cases involving disputes. What I found was illuminating. The HOA's finances were a mess, with unexplained gaps in their reserve fund. Board meeting minutes showed Barbara making decisions unilaterally without proper votes. And most damning, I found records showing that 3 other homeowners had installed generators in the past 5 years without any HOA opposition. The difference? All 3 had been friends with Barbara or board members. I compiled everything and sent it to Jennifer. She was delighted. "This is selective enforcement, which is illegal under Texas Property Code," Jennifer explained. "The HOA can't allow some homeowners to have generators while prohibiting others, and the financial irregularities suggest potential mismanagement or fraud. We're not just dismissing their lawsuit. We're going after them." Jennifer filed a motion to dismiss the HOA's suit and simultaneously filed a counterclaim against the HOA and Barbara Kensington personally. We alleged harassment, selective enforcement of covenants, breach of fiduciary duty, and sought damages for my moving costs, legal fees, and the financial losses from selling my house earlier than planned. The legal process moved slowly, as these things do. But Jennifer was aggressive, filing discovery requests that forced the HOA to produce all their financial records, enforcement actions, and internal communications. She deposed Barbara, Gerald, and Patricia, asking pointed questions about their decision-making processes. Marcus agreed to provide testimony about the community center generator and the selective enforcement he'd witnessed. Several former homeowners came forward with their own stories of HOA overreach and Barbara's vindictive behavior. The HOA's attorneys tried to settle early, offering to drop their suit if I dropped mine. Jennifer and I declined. We wanted this on record. 6 months after the initial lawsuit, we had our day in court. The hearing was held in Fort Bend County, in a courtroom that was far too mundane for the drama that was about to unfold. The judge, a no-nonsense woman in her 60s named Margaret Thorne, had clearly read all the filings and was not impressed with the HOA's case. She dismissed their lawsuit against me within the first 15 minutes, calling it frivolous and without merit. Then she turned to our counterclaim. Jennifer presented our case methodically. She showed the selective enforcement through HOA records, demonstrated that my generator met all legal requirements, and established that I'd been targeted specifically because I hadn't sought Barbara's personal approval. Barbara took the stand and tried to defend her actions, claiming she'd been protecting property values and community standards. Jennifer tore her apart on cross-examination. "Miss Kensington, can you explain why Robert Morrison was allowed to install a generator in 2021 without any HOA opposition?" "I don't recall that specific case," Barbara said stiffly. "Let me refresh your memory." Jennifer pulled out the HOA minutes. "Robert Morrison, who served on the board with you from 2020 to 2022, installed a generator nearly identical to Mr. Dalton's. There's no record of any violation notice or fine. In fact, the minutes from the board meeting that month show you personally congratulating him on being prepared for emergencies." Barbara's face reddened. "That was different. Robert consulted with the board first, did he?" "Because there's no record of any formal consultation or approval in the meeting minutes. And Texas law requires HOAs to document all official actions. So either the board failed to document its decision, which violates the bylaws, or Robert Morrison's generator was approved informally, while Mr. Dalton's identical installation was fined. Which is it, Miss Kensington?" Barbara stumbled through an explanation that satisfied nobody. Jennifer continued. "Let's talk about the community center generator that Mr. Dalton mentioned. That generator is louder and less efficient than his installation, correct?" "The community center serves all residents," Barbara said, falling back on her previous argument. "That's not what I asked. Is it louder and less efficient? The specifications are different." "Miss Kensington, I have the technical specifications from Marcus Rodriguez, the engineer who installed both systems. The community center generator operates at 78 decibels at 20 feet. Mr. Dalton's operates at 65 decibels at the same distance. The community center generator produces more emissions and consumes more fuel per kilowatt-hour generated. These are objective facts. You dispute them." "I'm not an engineer," Barbara said defensively. "No, but you are the president of an HOA that fined a homeowner for installing equipment superior to your own while claiming it violated noise and aesthetic standards. Isn't that the definition of hypocrisy?" The HOA's attorney objected, but the damage was done. Jennifer then presented the financial irregularities, showing how the HOA's reserve fund had been depleted without proper documentation or homeowner notification. She demonstrated that Barbara had used HOA funds to pay for legal opinions from her personal attorney on matters unrelated to HOA business. And she showed that the board had repeatedly made decisions without proper quorum or votes, violating their own bylaws. By the time Jennifer finished, It was clear that the HOA wasn't just guilty of harassing me. They were guilty of mismanagement, selective enforcement, and possibly fraud. Judge Thorne didn't hesitate. She ruled in my favor on all counts, awarding me damages of $45,000 to cover my moving costs, lost equity from the rushed sale, legal fees, and punitive damages. She also issued an injunction requiring the HOA to conduct an independent audit of its finances and to adopt new procedures for enforcement actions to prevent selective application of rules. But she wasn't done. "Miss Kensington," Judge Thorne said, addressing Barbara directly, "the evidence presented in this case suggests that you have grossly mismanaged your duties as HOA president. You've applied rules selectively, used HOA funds inappropriately, and conducted board business in violation of the organization's bylaws and Texas law. I'm ordering you to step down from the board immediately." Barbara looked stunned. "Your Honor, the HOA board is elected by homeowners. You can't simply remove me." "I can and I am," Judge Thorne replied. Under Texas Property Code Section 209.007, a court may remove an HOA board member for good cause, including breach of fiduciary duty and violations of governing documents. You've demonstrated both. You're removed from the board effective immediately. The ruling sent shockwaves through Riverside Estates. Word spread quickly, and I started receiving messages from current and former residents thanking me for standing up to Barbara. Several mentioned that they'd been afraid to challenge her, knowing she'd make their lives miserable. The independent audit that Judge Thorne ordered revealed even more problems. The HOA's reserve fund was short by nearly $70,000, the result of poor record-keeping, unauthorized expenditures, and what the auditor delicately termed potential misappropriation of funds. The new board, elected in an emergency homeowner meeting after Barbara's removal, voted to refer the audit findings to the Fort Bend County District Attorney's Office. 3 months later, Barbara Kensington was indicted on charges of misapplication of fiduciary property, a felony in Texas. The charges alleged that she'd used HOA funds for personal expenses, including legal fees for a property dispute unrelated to the HOA, and home improvement bills that she'd disguised as community center maintenance costs. I followed the case from a distance, living my life in Dripping Springs and watching Barbara's fall from grace with a mixture of satisfaction and sadness. I didn't hate her exactly. She was a cautionary tale about what happens when people get a little bit of power and forget that it comes with responsibility. Barbara's trial was held 9 months after my court victory. The evidence against her was overwhelming. The prosecution presented bank records, contractor invoices, and testimony from the auditor who'd reviewed the HOA books. Barbara's defense was weak, relying on claims that she'd been confused about which expenses were legitimate and which were personal. The jury didn't buy it. They convicted her on 3 counts of misapplication of fiduciary property. The judge sentenced her to 2 years in state prison, suspended, with 5 years of probation. She was also ordered to pay full restitution to the HOA, which totaled over $68,000. I never spoke to Barbara again after the trial. She became a pariah in Sugar Land, her name synonymous with HOA corruption. The last I heard, she'd moved out of state to live with relatives, trying to rebuild her life away from the neighborhood she'd once ruled with an iron fist. Meanwhile, my life in Dripping Springs flourished. I installed not 1 but 2 generators, a primary and a backup, because I could. I built a workshop addition without asking anyone's permission. I let my lawn grow to whatever height I wanted. And I never once missed the days of measuring my grass with a ruler to make sure it met HOA standards. Marcus thrived too. His consulting business in Austin grew rapidly, specializing in backup power systems for commercial properties. We collaborated on several projects, and he became one of my most trusted professional contacts. His experience with the Riverside Estates mess gave him a unique perspective on working with difficult clients and navigating political dynamics in building management. About a year after everything settled, Marcus and I met for lunch in Austin. We reminisced about the whole saga, marveling at how a simple generator installation had snowballed into legal battles, criminal charges, and ultimately the exposure of a corrupt HOA board. "Do you ever regret how it all played out?" Marcus asked me. "The stress, the legal fees, all of it." I thought about it for a moment. "No," I said honestly. "Moving was the best decision I could have made, not just to escape Barbara, but to get out from under any HOA. I'm never living in one again, and exposing the corruption. That needed to happen. Who knows how many more homeowners Barbara would have bullied if someone hadn't stood up to her." "True," Marcus agreed. "The new board is apparently much better. I heard they've relaxed a lot of the pettier rules and focused on actual community improvements." "Good. Maybe something positive came out of all the chaos." We finished lunch and went our separate ways, back to our respective projects and lives. I drove home to Dripping Springs, past open fields and hill country vistas. No HOA signs or community standards in sight. That evening, I sat on my back porch with a beer, listening to my generator run its weekly maintenance cycle. The sound was a low, comforting hum, barely audible over the evening breeze through the oak trees. My work computers hummed inside, connected to reliable power, my business secure. No fines. No violation notices. No Barbara Kensington telling me what I could or couldn't do on my own property. Just freedom, and the quiet satisfaction of knowing that standing up to petty tyranny, even when it's inconvenient and expensive, is always worth it in the end. The Riverside Estates HOA learned a hard lesson about selective enforcement and abuse of power. Barbara Kensington learned an even harder lesson about the consequences of treating homeowners as subjects rather than stakeholders. And I learned that sometimes the best way to win a fight isn't to win the fight at all, but to simply walk away to somewhere better. 6 months later, I got an unexpected call from a lawyer representing the new Riverside Estates HOA board. They wanted to know if I'd be willing to consult on updating their covenants to explicitly allow backup generators while providing reasonable guidelines for installation and operation. I thought about it for exactly 3 seconds before declining. Some bridges are better left burned, and some neighborhoods are better left in your rearview mirror. Riverside Estates had its chance to do the right thing, and they chose Barbara Kensington's ego instead. That wasn't my problem anymore, and that felt absolutely perfect. Instead, I reached out to Marcus, and together we created a consulting guide for HOAs on implementing reasonable backup power policies. We distributed it free to HOA boards across Texas, hoping to prevent other homeowners from facing the kind of nonsense we dealt with. The guide was well received, and several HOAs adopted our recommendations, creating clear, fair policies that protected both property values and homeowner rights. It was a better legacy than anything Barbara Kensington ever accomplished in her years of petty dictatorship. Today, I'm sitting in my home office in Dripping Springs, working on designs for a new hospital complex in Dallas. My generators are maintained and ready. My power is reliable. And I answer to nobody but my clients and myself. Sometimes people ask me if I ever think about what would have happened if I just removed the generator and complied with the HOA's demands. Would I still be in Sugarland? Would Barbara still be in power? Would the corruption have continued unchecked? The answer is yes to all three. And that's exactly why I don't regret a single decision I made. Standing up to bullies, even institutional ones hiding behind covenants and bylaws, matters. It matters for your own self-respect, and it matters for everyone else who might be bullied after you. The cost was real, the stress was real, but so was the victory and the positive change that came from it. I learned that HOAs aren't inherently evil, but they're powerful tools that can be used for good or ill depending on who's wielding that power. I learned that technical expertise and professional credentials matter when you're fighting bureaucratic battles. And I learned that sometimes the smartest strategic move is to remove yourself from a bad situation entirely rather than grinding yourself down trying to fix it. Most importantly, I learned to value freedom over convenience. An HOA-free property might require more responsibility and self-management, but that's a trade I'll make every single time. My property, my rules, and nobody sending me nastagrams about my lawn height or generator runtime. As the sun sets over the Texas Hill Country, painting the sky in shades of orange and purple, I fire up the grill on my back patio. My generators hum quietly in the background, ready to keep my home and business running no matter what the weather or power grid throws at me. No HOA can take this away. No Barbara Kensington can fine me. No board meeting can overrule my decisions about my own property. That's not just victory. That's freedom. And it was worth every penny, every minute of stress, and every hour in court to achieve it. The young couple who bought my old Sugar Land house eventually reached out to me, about 8 months after they moved in. They'd had their own run-ins with the new board over minor violations. Nothing as dramatic as my generator fight, but enough to make them question their decision to buy in an HOA neighborhood. I shared my story and my advice. Document everything, know your rights, and don't be afraid to stand up for yourself. But most importantly, start planning your exit strategy, because life's too short to spend it fighting with people who think a 3-inch grass height violation is important enough to warrant a fine. They thanked me, and I wished them luck. I hope they find their way to greener, HOA-free pastures someday, just like I did. Barbara Kensington's probation violations, when they came, surprised nobody who dealt with her. 18 months into her sentence, she violated the terms by failing to make her restitution payments on time. The judge wasn't sympathetic, having warned her explicitly about compliance during sentencing. She served 6 months in county jail, enough to make the consequences of her actions undeniably real. I felt no particular satisfaction at the news, just a sort of tired acknowledgement that justice, slow and imperfect as it is, had been served. The HOA thrived without her, implementing reforms that made it one of the better managed communities in Sugar Land. They hired professional management, created clear appeals processes for violations, and yes, they updated their covenants to allow generators under reasonable guidelines. It was proof that the problem had never been the HOA structure itself, but the person who'd wielded its power without accountability or fairness. As for me and Marcus, we stayed friends and occasional collaborators. He'd sometimes drive out to Dripping Springs for barbecue and shop talk, and I'd visit Austin for client meetings and catch up over dinner. We joked sometimes about our shared experience as the rebels who'd taken down a corrupt HOA. But mostly, we just lived our lives and pursued our careers, without the constant background stress of wondering what violation notice would show up next. Freedom turned out to be exactly as good as I'd hoped it would be, and I never took it for granted. Every time I ran my generator, every time I made a property improvement without seeking permission, every time I looked out over my 4 acres with no violation notices in sight, I felt grateful for the decision to leave. The story of my generator, my move, and the HOA's downfall became something of a legend in Sugar Land. People referenced it in HOA meetings, used it as a cautionary tale about board overreach, and cited it when advocating for policy changes. My name became shorthand for standing up to unjust rules. I never sought that notoriety, but I didn't shy away from it either. When people asked for advice about fighting HOA violations, I shared what I'd learned. When new homeowners asked whether they should buy in an HOA neighborhood, I gave them the unvarnished truth about what they were signing up for. And when people asked if I'd ever move back to an HOA community, I laughed and told them that my generator and I were very happy where we were. Thank you very much. The full circle moment came 2 years after everything settled, when I got a call from a reporter at the Houston Chronicle. She was writing a feature story about HOA governance issues in suburban Texas and wanted to interview me about my experience. We talked for over an hour. I told her everything, from the initial fine to the legal battles to the criminal charges against Barbara. The reporter was thorough, professional, and genuinely interested in the broader issues beyond just my personal story. The article ran on a Sunday front page of the Metro section, with the headline "When HOAs Go Bad: How One Homeowner's Generator Led to Criminal Charges." It was fair, well-researched, and sparked significant conversation about HOA reform in Texas. I received dozens of messages after the article ran, from homeowners across the state sharing their own HOA horror stories. Some had fought and won, others had fought and lost, and many had simply given up and moved away like I had. The common thread was frustration with a system that gave small groups of people disproportionate power over their neighbors with minimal oversight or accountability. The article, and the conversation it sparked, contributed to legislative discussions about strengthening HOA governance laws in Texas. I don't know if my experience single-handedly changed anything, but I like to think it added to the momentum for positive change. Sometimes that's all you can do. Tell your story, stand up for what's right, and hope it makes a difference for someone else down the line. Now, years later, sitting in my paid-off house on my HOA-free property, I can look back on the whole saga with perspective. It was stressful, expensive, and time-consuming. It disrupted my life and cost me money, but it also taught me valuable lessons about property rights, standing up to bullies, and the importance of freedom. Would I do it all again? In a heartbeat. Because the alternative, living under Barbara Kensington's thumb and pretending that was normal or acceptable, was no way to live at all. My generator still runs faithfully, providing backup power when storms knock out the grid, which happens less frequently out here than it did in Sugar Land. Every time it kicks on, I think about that first violation notice, Barbara's red face at the board meeting, and the long road from that moment to where I am now. And then I smile, make myself a cup of coffee powered by my own generator, and get back to work in my home office, grateful every day for the freedom to live life on my own terms. That's the real victory. Not the court judgment, not Barbara's conviction, not even the vindication of being proven right. The real victory is the quiet satisfaction of living free from arbitrary rules and petty tyrants, master of my own property and my own choices. My generator runs. My business thrives. My life is my own. And Barbara Kensington is nothing more than a cautionary tale I tell at barbecues. In the end, that's exactly how it should be.